and the jurors, anything we need to address?
Maybe we can see inside.
Yes, of course.
Jurors,
Yes, thank you. It's on the desk.
attention, all right. May be seated.
All right, jurors, good afternoon.
At Kroger, we're excited to share lower prices on thousands of high-quality fresh items every week, so you can celebrate savings every day. Kroger, fresh for everyone.
Given to the lawyers to address you. It's an opportunity for the attorneys to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you are about to hear is not evidence. Lawyers are not witnesses. All the evidence in this case has been presented through the testimony of the witnesses and the exhibits, which you will have an opportunity to examine and consider during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or disfavor either side. For example, the attorneys are not permitted to refer to facts that are not in evidence in this case. If based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal belief in the credibility or lack of credibility of any witness who testifies in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If you become conscious of any passion or prejudice as you consider the evidence or engage in your deliberations, you must put those feelings aside and not permit them to influence your thinking. And if a lawyer makes such a comment, you must disregard that comment. Better proceed. Bless you.
Good afternoon again, ladies and gentlemen. As I said to you in my opening statement, there was no assault, no strangulation, no incident at all on that day or any other day. You didn't see any injuries. You didn't see any photographs. You learned there were no medical records, no statements, no nothing between December 2nd and December 16th. You have not been provided with a single shred of credible evidence to determine that any assault actually occurred in the house on that day. The Commonwealth's case is nothing more than the words of Miss Adams. In my opening statement, I told you one tool to use as you go through this process is to consider how to find the truth. That the simplest answer that accounts for all the facts, that answer is the truth. And so what I want to do is take you through some of the undisputed facts in this case. December 2nd, Ms. Adams spent the afternoon talking on the phone. She got a ticket to Atlanta. She cooked Stefon Diggs dinner. We learned this morning that it was a hot dog. She went into Mr. Diggs's bedroom to provide him birthday presents and to deliver those birthday presents. Timeline-wise, all of this, every single fact that I just mentioned, all of those would have occurred after what Miss Adams says was a violent assault that occurred sometime that afternoon. That night, Miss Adams left the house at 7:15 and she flew to New York City. You heard that she told the police that she stayed with friends. You heard her describe whose friends they were. But you also heard her say that she had a ticket to Atlanta, purchased before she ever changed it to go to New York City. You saw videos of Miss Adams when she arrived in New York. You heard from the woman who picked her up from the airport, who also saw Miss Adams when she arrived in New York. You saw video and heard from Tali Moses, who spent the entire week with Miss Adams in New York. And you got to see how she looked. You got to see her face. You got to see her neck. You got to see the way she moved during the course of that week. One thing I'll say about that, Miss Adams, she might define bruising, however, is expedient or convenient for her, but we all know what bruising looks like. You saw the videos and you heard from the witnesses. On December 5th, Miss Adams texted Stefon Diggs, "Hi, can you please approve my pay with finance, please and thank you." That would have been 2.5 days after he violently strangled her in her bedroom. December 6th, you saw the video of her dancing. That's 3.5 days after this assault allegedly occurred. You heard that throughout the course of that week, from December 2nd to December 9th, Miss Adams didn't mention a single thing about any assault to anyone. The one thing you heard her mention was on the afternoon of December 2nd, she told Shy she wasn't going to Miami. You heard that on December 9th, she went back to the house. And I told you the details were going to be important about her going back to the house in my opening statement. She got back to the house at 11:30 p.m. alone and walked into the house. But what did she do? She didn't just go to Stefon Diggs's bedroom door and knock on it. She tried to punch in the code, and it didn't work. And those are her words. That's what she told you. None of that is consistent with a violent assault having occurred the last time they interacted with one another. Not one piece of that. And those are undisputed facts. On December 11th, Miss Adams texted Mr. Diggs her apology. She said she was sorry she was being emo, and she didn't want him to feel that way. She didn't want him to think she was trying to quit her job. And she told you she was trying to keep her job. She was trying to get back. She also told the police 4 days later, 5 days later, that she had quit her job on December 2nd. We know that that was a lie. Not just from the fact that she actually told you that that was a lie, but from the actual evidence that you have in this case that is undisputed. That evidence goes on. She told Mr. Diggs's girlfriend that she didn't say any of that to the police, meaning what she told the police, that she didn't accuse Mr. Diggs of assault. And that wasn't true. She also, a month later, told the world that she had never demanded money. And that also wasn't true. Now, more undisputed facts. Miss Adams was paid for November. At first, she didn't admit that. She ended up saying they worked it out. she got paid for 2-3 weeks. And we actually got an answer today on why she wasn't paid for a full month. Because she was in Tobago with Shy Charles. You heard from Melissa Goddard. Miss Adams was paid up. The non-disclosure agreement. Miss Goddard talked to you about that. And you heard about that from Miss Adams. I want you to look at the text message in Exhibit 4. It's on page 195. We talked about it a little bit yesterday afternoon. But this is another undisputed fact, and it's very important. Because despite what Miss Adams told the police on December 16th, and told you at times yesterday, on December 13th, 2025, Miss Adams says what she thinks the NDA is about. And she says, you sitting here playing in my face, 700 comments. If I told someone why it's not in the blog, you believe it, meaning Mr. Diggs, and now sign an NDA. Send me my money. You sitting here playing in my face. Miss Adams wants you to believe she wouldn't tell Shy Charles because Shy Charles knew Mr. Diggs. That requires you to completely ignore the fact that she chose freely and willingly to go to New York to stay with Shy Charles. December 13th, she told Mr. Diggs, she told Stefon Diggs what she thought the NDA was all about. And it was about the blog issue. You think it might make a little sense if the NDA was about any kind of a physical assault, a strangulation? That she might say to him anything. Hey, you know what this NDA is really about. Or maybe just, the NDA, because you assaulted me? Not a word. She describes why that's there. And those are her words from December 13th. And that is undisputed. Now let's talk about the police for a few moments. Because Miss Adams went to the police, as you heard, on December 16th. And there's other undisputed facts in this report. She lied to the police. She did not leave her job. Miss Adams told you something yesterday where she said, well, left my position was like in the house, but that wasn't my job. And you heard what Officer Ellis said this morning. I said, you mean her position, as in her job? And he said, of course. She told Officer Ellis that she just went back to get her stuff. And you know that isn't true. And at times, she seemed to admit that that wasn't true. And you know from her own words at the time to both Mr. Diggs and to Sonny that that wasn't true. The text message that you've heard about the deletion. There's two things that I want you to pay close attention to and that I want to talk to you about in both Exhibit 1 and Exhibit 2. Exhibit 1, the text message that she sent purporting to be a screenshot of the argument that led to a violent assault that ended with Mr. Diggs choking her. That's what she told Officer Ellis. And you heard that from him this morning. You also heard from her that she deleted messages. And I think what she said was something like, I didn't want to look bad, or something along those lines. And if you look at what was actually deleted, the word she was saying bet and pussy were what she deleted, that's what she did. She did delete those messages, right? Those are not in the text messages that she provided to Dedham police. But more importantly, what she actually deleted that wasn't about making her look bad or not, it was right after the words, "I'm out of your life." And it said, "and ruining that bitch life." And then you can actually go to Exhibit 2 and look, there's a fairy emoji she sent. And why that's important is because, as you heard from Officer Ellis this morning, it'd be important to know if somebody deleted messages. It'd be important to see the full picture. And that message right there, and ruining that bitch life, apologies for the language, with the fairy emoji, you think that might have prompted the question, hey, who's that bitch? She answered the question for you yesterday. It was Lindsay. The argument wasn't about money. You have it in evidence. And Miss Adams later admitted that. These lies to the police, the fact that they're undisputed, why? Look at all of those facts. They're undisputed in the record. They are all there. If you remove from those facts one thing, that an assault occurred, they all make sense. If you plug in that she was assaulted that afternoon before all of this happened, before everything I just read to you, none of it makes sense. Why would a person who was just strangled go down to the kitchen, chat on the phone, and not have a single mark on their face or look even remotely bothered? Why would that same person cook dinner for the man who just did it? Why would that same person knock on his bedroom door and deliver 2 birthday presents? Why would she act the way she did for the next week? And then why lie about it repeatedly to the police? And what ended up happening next, just chronologically, gives away the game on that. Because what you heard is that only a couple weeks later, her mediator made a demand for money. And if you plug that fact in, now it all makes perfect sense. We have provided evidence to you. We have presented evidence. We have called witnesses. As I said, we're doing so in order to give you the fullest picture of December 2nd and of what happened or did not happen. And think about that for one moment. How do you prove a negative? It's basically impossible, right? Pick a day 2 months ago, account for every action that you did on that day, every moment of your day. Great, now prove it. Can't be done. And this trap, the framers of our system, they were aware of it. And that's why it works the way that it does. The burden is on the Commonwealth to prove their case. And their case, as you have seen, is the internally inconsistent testimony of one witness. And that is their entire case. And that is not enough to meet their burden. The burden that you are going to hear is reasonable doubt. And the judge is going to tell you that that's to a moral certainty. How much would you bet on the words of Jamila Adams? Would you bet your own life, someone else's? You have all of the tools in what I just laid out for you to make a credibility assessment. But it is not only that. Because the other thing the judge is going to tell you is you can actually take into account the way the witness answered questions, behaved, their demeanor, how they looked. Did they sound consistent? Did the things they say actually at least stay true internally in their own story? And one example I'll give you on that is this morning when Ms. Adams was asked about another monetary demand. She didn't answer the question. She couldn't. She wouldn't. She gave you multiple excuses. She tried to say attorney-client privilege, and when there was no response to that, she said, I can't answer that correctly. Take the way she answered questions into account, but line it up against the facts that you know that you have, because that's how you got to make a decision, on facts, on evidence. In terms of the evidence that the Commonwealth has actually presented to you, what they have presented to you are the claims of one person. Their second witness undermined their first. And there's a reason for that. There's a reason they had absolutely nothing to corroborate this allegation, which one thing I will say about the assault and battery, she described Mr. Diggs slapping her on the right side of her face with his right hand. And she actually demonstrated it for you. But the problem is that's a physical impossibility. And the reason I would suggest to you that that demonstration didn't go quite well is because sometimes people miss their mark. Sometimes actors forget the script. What you do not have before you is anything that you can base a firm decision on, unless that decision is that the Commonwealth has not proved its case. The Commonwealth has an opportunity to speak to you after I do. And you heard the Commonwealth question some witnesses about working for Mr. Diggs. There's a number of people who were called as witnesses. We tried to be as quick as possible. It's not terribly exciting to hear a witness talk about how they heard and saw nothing. But for a moment, stop and think and ask yourself, if you were accused of having something happen at your house on some random day 3 weeks ago, who would be there with you? The people closest to you. It'd be your family, the people who are in your house all the time. And for Mr. Diggs, we talked about that. That's staff. That's Miss Salas. That's all the people that you heard from. One thing that I want to talk about is a reason for bias. Because when Mr. Virtue asked, I think the first witness she was Miss Salas. Mr. Diggs paid her salary, isn't that right? The one witness who has the most significant financial interest in this is Jamila Adams. You heard her talk a lot about money yesterday, and that was the Commonwealth's only witness to even touch on what they claim.
So, here is a before of my stomach before Sonobello, and this is after.
Their evidence. They cannot, and they have not, proved this case because no assault occurred on December 2nd, or as I said, any other day. And it's your obligation to hold them to that burden and to decide the case on the evidence that you have in front of you. And that evidence provides one answer alone. And I would suggest to you that is that Miss Adams made this accusation as a means of trying to leverage and humiliate and to punish Stefon Diggs. And you heard that he has been living with this case and these accusations since December of 2025. And it is time to end. The evidence that you have heard that has been put before you is not enough for the Commonwealth to sustain their burden. It is your obligation to return a true and a just verdict. And the evidence that you have heard requires that you go back into that room and that you lift this burden off Mr. Diggs' shoulders and that you tell him and the world that Stefon Diggs is not guilty of this incident that never occurred. Thank you.
Good afternoon. Feels like it's been a little while since the last time I talked to you guys directly. So, was Miss Adams a perfect witness? No. She was argumentative, avoided, difficult. But does that mean you should throw away everything she says? She said, no. I think it'd be easy for you guys to do that, but that's not your job. You guys are the jury. It's your job, your sacred duty, to comb over every bit of evidence you heard, to consider it, to give it the attention it deserves, the attention, the scrutiny, the weight it deserves. You don't have to like Miss Adams. You don't have to like the way she testified today and yesterday, but you do have to give her and her testimony the attention it deserves. You heard from her about what happened in that room on December 2nd. She said he entered the room, slapped her, put her in a headlock, said some things to her. I suggest if you remember how she was testifying, I think the way she was testifying to that lends some to her credibility. She was taking her time. She was looking. She was trying to remember things. As the defense counsel predicted, one of the things I'm going to say is that Miss Adams was the only witness you heard from about what happened in that room. You have defense's witnesses who said what happened afterwards, but if you remember Miss Adams' testimony, she said that was after she had an opportunity to kind of put herself together. She said she cried, she changed her clothing, she kind of started packing. The question you may be having is, why would she act that way? Why was she going out and smiling? Well, I'd suggest to you that all the people she was around are people that have known Mr. Diggs much longer than they've known her. I'd suggest you even consider the relationship she had with Mr. Diggs. He was sometimes lover, a boss, landlord. He was a athlete, a celebrity, financially powerful, surrounded by people that were all on his payroll that liked him. That when you put that all in consideration, her behavior does make sense in that it was her way of continuing on past that. And she told you that they had a complicated relationship. She said they argued all the time. So that might also make sense as to why she texted them afterwards saying, hey, trying to make amends or trying to figure things out, why she gave the birthday present afterwards. In this case, you heard four kind of things, right? You heard things that weren't evidence. The openings, these closings, questions, things that were stricken, those are things that aren't evidence. They can kind of give you some context, but those aren't the evidence in and of themselves. You heard the actual evidence. That was the testimony from the witnesses, the videos, photos, and you'll be able to see also all those text messages. The third thing you're going to hear, so things that aren't evidence, things that are evidence, and the law. The judge gave you some preliminary law at the start of the case. She's going to now, once closings are done, instruct you on the full law. I ask that you give her the same attention that you've given to all the evidence, and you've given the same attention to both attorneys during their closing. You give the judge that attention when she reads the law. And there's a fourth thing that you're going to need to pay attention and listen to and consider, and that's each other. When you guys are done here, once I finish, once the judge reads the law to you guys, it'll be your job to go into that room and deliberate on this case. When you go in that room, it's up to you guys how you want to run it. There's no manual, there's no guide, there's no schedule of how you guys are going to come to your decision and reach your verdict. And no one is going to make sure you're doing it one way. What I would suggest you guys do, and you guys can do whatever you want, this is just my suggestion to you. What I suggest you guys do is you don't go in there and just say, all right, let's take a poll right off the bat. I suggest you guys take the time, go over all the evidence, go over each witness, talk about each witness, try and do it both ways, back and forth, for every witness, not just the Commonwealth's defense as well. Go over every bit of evidence. Really take the time that this case deserves. And also listen to each other. I'd suggest as much as you can, make sure if there's someone that's that's not saying anything, make sure you get to hear from them as well. As I said at the start of this case, that every bit of evidence is important, and that's true. I'd hope that if you guys fairly treat every bit of evidence the attention it deserves, give the analysis, the scrutiny for all the witnesses, all the evidence, and talk amongst yourselves, that you guys will come to the correct verdict. And I would suggest that that verdict is the verdict of guilty on all counts. Thank you very much.
Very briefly.
Sure. All right, jurors, you are about to begin your final duty, which is to decide the fact issues in this case. Before you do that, I will instruct you on the law. It was obvious to me throughout this trial that you faithfully discharged your duty to listen carefully to all the evidence and observe each of the witnesses. I now ask you to give me that same close attention as I instruct you on the law. My function as the judge in this case has been to see that this trial was conducted fairly, orderly, and efficiently. It was also my responsibility to rule on what you may consider as evidence and to instruct you on the law which applies in this case. It is your duty as jurors to accept the law as I stated to you. You should consider all my instructions as a whole. You may not ignore any instruction or give special attention to any one instruction. You must follow the law as I give it to you, whether you agree with it or not. It was the duty of the attorneys in this case to object when the other side offered evidence which that lawyer believed was not admissible under our rules of evidence. They also had an obligation to ask to speak to me, with me at the judge's bench at sidebar about questions of law, which the law requires me to rule on out of your hearing. The purpose of such objections and rulings is not to keep relevant information from you, just the opposite. It's to make sure that what you hear is relevant to this case and that the evidence is presented in a way that gives you a fair opportunity to evaluate its worth. You should not draw any inference, favorable or unfavorable, to any attorney for objecting to proposed evidence or asking me to make such rulings. That is the function and the responsibility of the attorneys here. Now, your function as the jury is to determine the facts of this case. You alone determine what evidence you believe, how important any evidence is that you do believe, and what conclusions to draw from that evidence. In making these determinations, you are to use your common sense, life experience, and good judgment. You are to decide what the facts are solely from the evidence admitted in this case. In evaluating the evidence and determining the facts, keep in mind that we all tend to perceive information and form opinions based on our own personal experience and background. This tendency may cause us to hold bias, of which we may or may not be conscious. And as I previously instructed you, you must not allow bias, whether held consciously or subconsciously, to interfere with your ability to fairly evaluate the evidence, apply the law as I instruct you, or render a fair and impartial verdict based on the evidence before you. The evidence consists of the testimony of witnesses as you recall it, any documents or other things that were received into evidence as exhibits may also be considered. Of course, the quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses. It's the weight of the evidence that is important. Some things that occurred during a trial are not evidence, and you may not consider them as evidence in deciding the facts of the case. The complaint itself is not evidence. A question put to a witness is never evidence. Only the answers are evidence. Also, you may not consider any answer that I struck from the record and told you to disregard. Do not consider such answers. Anything that you may have seen or heard when the court was not in session is not evidence. The opening statements and the closing arguments of the lawyers are not evidence. They are only intended to assist you in understanding the evidence and the contentions of the parties. If your memory of the testimony differs from the attorney's, you are to follow your own recollection. You should not consider anything I have said or done during the trial as any indication of my opinion as to what your verdicts should be. In evaluating a witness's testimony, you have to decide what testimony to believe and how much weight to give that testimony. You should give the testimony of a witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of a witness. You may believe everything a witness says, part of it or none of it. If there are any conflicts, discrepancies, or inconsistencies in the testimony, you should examine them carefully. You may consider whether a witness was candid or guarded, responsive or evasive, and whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity a witness had to observe the facts about which the witness testifies and whether the testimony seems accurate. You may also consider evidence, if any, about a witness's motive for testifying, whether a witness displays any bias in testifying, and whether or not a witness has any interest in the outcome of the case. In deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense, life experience, and good judgment. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you have gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. Once you have determined the facts, apply the law as I explain it to you to the facts in order to decide the verdicts. Now, there are two types of evidence which you may use to determine the facts of a case: direct evidence and circumstantial evidence. You have direct evidence where a witness testifies directly about the fact that is to be proved based on what he claims to have seen or heard or felt with their own senses. And the only question is whether you believe the witness. You have circumstantial evidence where the witness cannot testify directly about the fact that is to be proved, but you are presented with evidence of other facts, and you are then asked to draw reasonable inferences from them about the fact which is to be proved. Let me give you an example. Your daughter might tell you one morning she sees the mail carrier mailbox. That's direct evidence that the mail carrier has been to your mailbox. On the other hand, she might tell you only that she sees mail in the mailbox. That's circumstantial evidence that the mail carrier has been there. No one's seen the mail carrier, but you can reasonably infer that the mail carrier has been there since there is mail in the box. The law allows either type of proof in a criminal trial. There are two things to keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you. The second rule is that any inference or conclusion which you draw must be reasonable and natural based on your common sense and experience of life. If the Commonwealth's case is based solely on circumstantial evidence, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear and settled belief that the defendant is guilty, and that there is no other reasonable explanation of the facts as proven. The evidence must not only be consistent with the defendant's guilt, it must be inconsistent with his innocence. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all the evidence in the case. Now, when you consider whether to believe a witness or how much weight to give their testimony, you may consider whether that witness said or wrote something earlier that differs in any significant way from their present testimony in the courtroom. It is for you to say whether there is a difference and how significant any difference is. Please note that you may not use the witness's earlier statement as proof that something said in it is true. So, for example, if a witness testified here that she found a donut but had earlier written that they found a bagel, that earlier statement would not prove they found a bagel, but it might raise doubt as to whether they were accurate or truthful when they testified that they had found a donut. So the earlier statement is brought to your attention for the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. It's for you to decide whether it does so. Normally, you may not consider any statement that a witness made in the past which is similar to that witness's testimony at trial. The rule rests in part on our common experience that saying something repeatedly doesn't necessarily make it any more or less true. But we make an exception to that rule where there has been a suggestion that a witness may have recently contrived their testimony. In determining how reliable a witness is who has been accused of recently inventing their testimony, you may consider any earlier statements that the witness made, which are consistent with their present testimony. It's for you to say how important the consistency is depending on depending on when any earlier statement was made and any other circumstances that you consider significant. The earlier statement is not itself evidence of any fact that is mentioned in it. to repeat if there has been a suggestion that a witness recently contrived their testimony at trial. When you evaluate that claim, you may also take into account any earlier statement the witness made, which is consistent with their present testimony. The prior statement is relevant only as to the witness's credibility, and you may not take it as proof of any fact contained in it. At this trial, you may have noticed that the defendant did not testify. The defendant has an absolute right not to testify, since the entire burden of proof, in this case, is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that he is innocent. The fact that the defendant did not testify has nothing to do with the question of whether he is guilty or not guilty. You are not to draw any adverse inference against the defendant because he did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. As I have told you, the complaint against the defendant is only an accusation. It is not evidence. The defendant has denied that he is guilty of the crimes charged in the complaint. The law presumes the defendant to be innocent of the charges against him. That compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since he is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless his guilt has been proved beyond a reasonable doubt. Your verdict, whether it is guilty or not guilty, must be unanimous. Now, as I've said, the burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if after you have compared and considered all of the evidence, you have in your mind an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until they are proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence,
an entire season, all building to this
point, championship point,
all or nothing stakes on the
that is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. The defendant is charged with having committed an assault and battery upon Mila Adams. In order to prove the defendant guilty of committing an intentional assault and battery, The Commonwealth must prove three things beyond a reasonable doubt. First, that the defendant touched the person of Mila Adams. Second, that the defendant intended to touch Mila Adams. And third, that the touching was either likely to cause bodily harm to Mila Adams or was offensive. To prove the first element, the Commonwealth must prove the defendant touched Mila Adams. A touching is any physical contact, however slight. A touching may be direct, as when a person strikes another, or it may be indirect, as when a person sets in motion some force or instrumentality that strikes another. To prove the second element, the Commonwealth must prove that the defendant intended to touch Mila Adams, in the sense that the defendant consciously and deliberately intended the touching to occur, and that the touching was not merely accidental or negligent. The Commonwealth is not required to prove that the defendant specifically intended to cause injury to Mila Adams. To prove the third element, the Commonwealth must prove that the touching was either likely to cause bodily harm to Mila Adams or was offensive. A touching is offensive when it is without consent. If the Commonwealth has proven all three elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of the elements beyond a reasonable doubt, you must find the defendant not guilty. The defendant is charged with strangulation. To prove the defendant guilty of this offense, the Commonwealth must prove three things beyond a reasonable doubt. First, that the defendant intentionally applied pressure on the throat or neck of Mila Adams. Second, that the pressure was substantial. And third, that the pressure interfered with the normal breathing or circulation of blood of Mila Adams. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant intentionally applied pressure on the throat or neck of Mila Adams. The Commonwealth must prove that the defendant consciously and deliberately intended the touching to occur, and that it was not merely accidental or negligent. You may examine any evidence regarding the defendant's actions or words and all the surrounding circumstances to determine whether the defendant intended to apply pressure to the throat or neck of Mila Adams. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the pressure was substantial. You may consider evidence, if any, about how, where, when, and for what duration the pressure was applied, as well as any evidence of its effect or impact on Mila Adams. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that the pressure that was applied interfered with the normal breathing or circulation of blood of Mila Adams. If the Commonwealth has proven all three elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of the elements beyond a reasonable doubt, you must find the defendant not guilty. Counsel, I'll see you at sidebar. All right, jurors, when we impanel a jury at the beginning of a trial, we never know whether some personal emergency will arise during the course of the trial, which will require one of our jurors to be excused from further jury duty. So in order to avoid having to start the trial over again, should that occur, we impanel 7 jurors, even though the case will only be decided by 6 of them. So the time has now come to reduce your number to that 6. And I am going to ask Mr. Clerk to draw one of your cards at random, and that juror will be designated as our alternate juror and will not take part in the deliberations unless necessary to provide a substitute for one of the other jurors. So if fate makes you the alternate juror, please don't take it personally. Your service up to this point, your willingness to serve is appreciated by all of the parties, and we will make sure that you are kept as comfortable as possible in an area isolated from the deliberating jurors.
That would be juror number 1 and seat number 1.
All right. Stay right there. You will serve as our alternate, but as I say, we'll make sure you're kept comfortably in a different location. If you would be good enough, Mr. Clerk, to draw another card at random. This particular juror will be the foreperson of this juror.
All right, so there you have it. So the jury is in deliberation, and we'll see what happens. So who do you think? For what I didn't follow the case closely, so I don't know. It's just when I saw the defense and some of the testimony, so that's how I came up with. I don't think he'll be found guilty, but I don't know. I didn't follow the whole case, so who knows? But just from what I saw, it seems like they had a little bit more of a relationship. Like it was a little bit more than just employee-employer, definitely. So who knows? But I don't even know how much time he's facing. I don't know. So, but like I said, Brandy and I will be back tonight. We'll be back tonight about 9:30. So I'm going to let you guys have I'm going to let it go right here, I guess. I got to go out and vote today. We have primary election. So I'm going to vote. We have until 6:00. I meant to get out and vote earlier, so I could have did early voting, but my polling place is just around the corner from my house, so that's what I'm going to do. Get out and vote and try to do what we're supposed to do civilly, so we can have a better place to live. Shoot, because it's nuts. During this time, we don't know what's going on. Everybody's in for $1. But all I know the gas is $4.99 a gallon. So yes. So if you're in Ohio and Indiana, we have primary elections today. But with that being said, I'm gonna go and get my vote on. So peace. Uh-oh. You hear that? That's the T hitting the pavement. Over here on Word on the Curb, we don't sip, we spill. Word on the Curb, where the T hits the pavement. Let's get into it. It's Angela, your favorite internet bestie, and we got the vibe. We rocking the housewives, politics, and celebrity gossip, all wrapped into one show.